Hello and welcome to a special interview for TheWire.in. Even almost 3 weeks after the government acted, there's a lack of clarity about what exactly has happened to Article 370. Has it been abrogated or has it been de-operationalized? And even more importantly, there's lack of clarity about what powers Delhi now exercises over Jammu and Kashmir. Have they been enhanced? Or paradoxically, have they been in fact in some critical areas diminished? The answers to these questions are complicated and difficult and sometimes even hard to follow because they involve understanding the intricacies of the Constitution. But it's critical we come to grips with them because only then will we understand what's happened in Kashmir, what the impact is on our country, and most importantly, what the impact is on our democracy. With me to shed light on these critical issues is a gentleman who's taught law for 25 years. He is perhaps one of the greatest exponents of the Indian Constitution. He is presently Vice-Chancellor of the Nalsa University of Law, Professor Faizan Mustafa. Professor Mustafa, let's start with Article 370. It's not been abrogated, as many people believe, but its provisions have been used to de-operationalize Article 370 itself. Now, it's a complicated 2 or 3 step procedure. So can you start by explaining to the audience how exactly this has been done?
370 permits President of India to make modifications and exceptions in other articles while they are made applicable to Jammu and Kashmir. So they use this power to insert a clause in Article 367 and change the meaning of some of the crucial words which have been used in Article 370. One is Constituent Assembly of Jammu and Kashmir, which they said will now mean Legislative Assembly. The other is Government of State, which will now mean Governor acting on the advice of Council of Ministers. So basically, the text of 370 largely remains the same, but when we will interpret them, we will use 367 to arrive at an entirely different interpretation.
And because they've reinterpreted the word Constituent Assembly to mean Legislative Assembly, when they apply that interpretation back to 370, it means they can de-operationalize 370, not with the concurrence of the Constituent Assembly, but now with the concurrence of the Legislative Assembly.
Correct.
And this has permitted them, this reinterpretation has permitted them to de-operationalize Article 370. Is that right?
It was a very innovative way. I think we must compliment the government for finding a way to de-operationalize 370 without deleting 370 from the Constitution.
I'll come to this innovation that they've done, but the first point is you agree Article 370 has not been abrogated.
Yes, it has
remains on the statute.
Very much.
It's simply been de-operationalized.
Correct.
As a result of what you call innovative reinterpretation.
Yes.
Let's come to this innovative reinterpretation. As you pointed out, Article 370 permits the central government to enforce other articles of the Constitution in Jammu and Kashmir with modification or amendments. Did the framers of the Constitution ever intend that this power to modify or amend could be used to modify 370 itself?
No, because the word used within 370 is other provisions. So there are provisions mentioned in Article 370, which is Article 1 and 238. 238 does not exist anymore, so it is only Article 1. So they cannot use it to change 370 itself.
So the very phraseology of 370 makes it clear that the power of 370 to amend exists to amend other provisions, not to amend itself.
Because the expression use other provisions which the President of India with such modifications and exceptions would like to apply to Jammu and Kashmir.
So then this attempt to use 370 to modify or amend 370 itself is actually a form of constitutional sleight of hand.
Yes, you can say that.
One other thing, in 1973, in the Keshavnand Bharati judgment, the Supreme Court ruled that Parliament cannot amend what's called the basic structure of the Constitution. This was a limit placed on Parliament's capacity and power to amend the Constitution. Does a similar statute of limitations exist about the extent to which 370 can be used to amend the Constitution?
Whatever Parliament can do will be much more than what President can do. President is executive, Parliament is legislature. If the limitation applies on Parliament, how can president not be bound by basic structure?
So, in other words, in addition to the sleight of hand that we've discussed a moment ago, there is also a statute of limitations which determines the extent to which you can use 370, and the government has ignored that as well.
I would say at least the implied limitation should apply, because 370 is not just an ordinary article of the Constitution, it is an outcome of agreement between two sovereign states.
Now, clearly, the government's decision to use Article 370 to amend Article 370 will be challenged in the Supreme Court. As one of India's leading exponents of the law, do you believe there's a chance that the Supreme Court could strike this down as unconstitutional?
Yeah, no one can predict what will be the outcome of the legal challenge in Supreme Court, but our experience has been that when you have governments with massive majorities, court stay away from political questions. When there are coalition governments, they assert their power little more. And I have a feeling that when it comes to their own powers, they jealously guard them. But when it comes to constitution, citizens' liberties, the same kind of anxiety is not demonstrated by the court. So at best, the court will refer this question to the constitution bench, and the matter will be decided after 2-3 years. By that time, it will become redundant.
You're saying a very interesting thing, and I'm repeating it for the audience. You believe that in major important political decisions taken by majority governments, courts are reluctant to overturn them. And therefore, what the court will do is refer this matter to a constitution bench. That will take 3-4 years to set up, because there's a long waiting list of subjects waiting for constitution benches to be set up. And by that time, this will be a fait accompli, and therefore it will be accepted regardless of what verdict the court comes up with.
Yes, because court is not showing any anxiety even to issue notices. So many petitions were put up before the court. Court is talking of defects. You know, in public interest litigations, even a postcard has been treated as a petition.
So a very interesting conclusion is what we come to. In this case, something that you call a sleight of hand, something that clearly was not intended by the framers of our Constitution, will end up becoming a fait accompli, because the court will dilly-dally set up a constitution bench which won't give its verdict till 3 or 4 years, by when this will be a fait accompli. So lack of diligence on the part of the court will make sure this just happens.
We can't say diligence, because it is a constitutional question. They will say this question requires 5 judges.
Lack of urgency.
Ideally, they should show some urgency, because they must ideally pronounce on this before October.
And that looks very unlikely.
To me, it looks unlikely.
Let's come to a second critical aspect of what's happened, the manner in which the central government has split Jammu and Kashmir into two and then demoted both parts into union territories. Now, ordinarily, the Constitution requires that this can only happen after first seeking the opinion of the State Assembly. But as you know, the State Assembly doesn't exist. The government has said that under President's rule, the powers of the State Assembly transfer to Parliament, and as a result, the government can consult Parliament rather than have to consult the State Assembly. Do you agree with that line of logic?
Not entirely, because you have to look at the timeline. The timeline is that the presidential order is coming on 5th of August. 5th of August, Rajya Sabha, this bill is introduced and passed. Now, before 5th of August, you had Article 370 exception created for Jammu and Kashmir, which said their concurrence is needed of the Legislative Assembly, not ascertainment of views. So when was before 5th of August this bill referred to the Legislative Assembly? 2, the expression used is, say, after 5th of August, it becomes an ordinary state, and like any other state, views of the Legislative Assembly is to be ascertained. Now, views are not powers. There is a distinction between views and powers. Parliament can exercise the power on behalf of the Legislative Assembly. But here, public expression of views of people's representatives of that state must come to public fore.
And that hasn't happened. You're making a very important distinction. Under President's rule, Parliament can exercise the powers of a Legislative Assembly, but Parliament cannot express the views of the Legislative Assembly. And since the Constitution requires, before you change the borders or the status of a state, that you ascertain the views of the Assembly, those views have not been ascertained. And what the government claims as a process for doing so is therefore a second sleight of hand.
Definitely. Just recall about Telangana. The bill was referred in 2013 December to Andhra Assembly. 84 members in Assembly, 54 members in Council participated. 9,000 bills were moved. They rejected it, still Parliament enacted the law. But this was an expression of views. There is a difference between individuals' freedom of speech, which is subject to reasonable restrictions, and Parliament or Assembly's privilege to speak, which is absolute.
And in this particular instance, the Assembly's privilege to speak has not been exercised. And more importantly, the requirement of ascertaining the views of the Assembly has not been fulfilled. And the important distinction is, under President's rule, Parliament can assume the powers of an Assembly, but it cannot express the views of the Assembly. And if the Constitution requires that the views of the Assembly be expressed, that has not been fulfilled.
Yes, just give me half a second. Power means your capacity to change the legal relations. Say you have a power to arrest or not arrest, power to pass a law, not pass a law. Assembly's expression of view is not power, because those views cannot change anything. Parliament can ignore.
It's an opinion.
It is an opinion.
And that opinion has not been expressed.
Yes.
Now, this opens up an even wider question. Can, in the first instance, Parliament, assuming the powers of an Assembly, act in such a way as to actually abolish the state? And if it can, then it follows that all the other states of the Indian Union are in potential danger of being arbitrarily reduced to union territories if Parliament so wants to do.
Yes, they will first impose the precedent rule, then Parliament will act as a state assembly, but I don't think that this is as per the spirit of the Constitution.
Once again, therefore, this will be challenged in the Supreme Court. What are the chances the Supreme Court will strike this down?
If court makes a distinction between expression of views and power, it must be struck down. And already there is a talk 2 days before in Deccan Chronicle, there is a big news that Hyderabad is going to become next UT.
So tell me something. Do you believe the Supreme Court will make this distinction between powers and expression of views?
It will depend how lawyers who are challenging this reorganization of Jammu and Kashmir argue their case.
When I spoke to you about the challenge in the Supreme Court about the way 370 has been de-operationalized, you said it was unlikely that the Supreme Court would act with urgency because it's reluctant to challenge a major political decision taken by a government with a majority, and if it did, it will refer it to a constituent bench, which would take 4 or 5 years to be set up. Would the same happen here? The similar lack of urgency, the similar delay?
There is a difference. Our courts are increasingly becoming positivist. Positivists mean they think of law as a command of sovereign. So if Parliament passes some law, they think that it is valid. In fact, there is a presumption of every parliamentary law being constitutional. So about 370, they may say that President had this power, he exercised it. Here, if this expression, views and powers are distinguished, then Article 3 condition has not been met. And they may say that it is not right. Now, in that case, what will happen? There will be elections. And after the elections, the assembly will express its views. Central government will ignore those views as it did in respect of Telangana and reenact this law.
So even if in this instance, the Supreme Court were to find an objection and uphold that objection, it won't actually stop Kashmir being divided and reduced to union territory status, because new elections will be held. That assembly will express an opinion, it will be ignored as it can be, and the same thing will happen again.
That's what I feel.
All right, let's at this point step back in history. In 1947, when the princely states, including Jammu and Kashmir, acceded to India, they all did so by way of the same instrument of accession. The important question I want to put to you is this. Whilst all the other states subsequently merged, Jammu and Kashmir did not. Is that therefore the critical difference between Jammu and Kashmir as it was and the other states?
Jammu and Kashmir's relationship with India is sui generis. It's a unique relationship. We need to understand that British government about princely state did not have sovereignty, it had suzerainty. It had some control about their external relations. Indian Independence Act restored it, so they all became fully sovereign. So when they agreed with us, they said we are signing an instrument of accession on certain items, we will accept you. But they retained their sovereignty, and the Raja Hari Singh even did not sign the Privy Purse thing. They did not merge. They did not accept Privy Purses. Even their citizens during even British time were differently treated. That's why you have Article 35A. So there is a difference between merger and just signing instrument of accession. But even those who merged, there was an agreement that they will be paid Privy Purses. When we abolish Privy Purses, Supreme Court struck it down.
And in fact, the only Privy Purse that wasn't abolished when Privy Purses was abolished was Karan Singh's. He chose to give it up voluntarily because he was a member of the government of the time. But leaving that aside, you made a critical point. The difference between Jammu and Kashmir and the other states is that the others subsequently merged. Jammu and Kashmir did not. It only exceeded in terms of the instrument of accession. Let's come then to that instrument of accession. That accession happened in terms of three critical subjects: defense, foreign affairs, and communication. All the other powers were retained by Srinagar. Did the instrument of accession have any provision whereby the Indian government could unilaterally and arbitrarily amend the terms of accession?
No. In fact, on the contrary, there is an assertion in clause 7, as many as 9 clauses were there. Clause 7 clearly says that it will not fetter the powers of the king to have future agreements with India. He is not bound to accept future constitution of India, and his sovereignty will remain in respect of that state. And then 370, as you know, whenever you want to make a change, you need concurrence of the Constituent Assembly.
This is very clear. Now, these terms of accession had to be incorporated into the Indian Constitution, and Article 370 was devised for that purpose.
Right.
Am I therefore right in believing that Article 370 is first of all the link that connects Delhi with Srinagar, and secondly it's the clause which defines the relationship between Kashmir and the rest of India?
Yes.
In which case, why is Article 370 part of a section of the Constitution which is described as temporary, transitional and special provisions?
Because when we drafted 370, by that time Constituent Assembly of Kashmir has not met. It was temporary in the sense till the Kashmir's Constituent Assembly takes a view on it. Once Kashmir's Constituent Assembly has taken a view, then nothing can be done about it, because they have finalized the relationship with Indian Union.
So the term temporary referred to that period till the Constituent Assembly in Kashmir had been convened. Yes. Till the assembly was convened, the government in Kashmir was with whom the government in Delhi had to concur in any changes they made to the status of Kashmir. After the Constituent Assembly was convened, you needed the Assembly's concurrence. That's why
Constituent Assembly.
Constituent Assembly. That's why this clause was called temporary.
Yes, temporary would mean temporary in period of time. I give you 3 examples. Reservation in Parliament for SCs and STs, it was for 10 years. English as official language for 15 years. But there, when a period is mentioned, then it is temporary.
Article 369, which is the preceding article, is only for 5 years.
5 years, yes.
What is Article 369, just for those
who want to? It is talking about trade within a state, and the Parliament was given a power to legislate on it for 5 years, because the matter was treated as concurrent.
So you're making a very important point, where in fact the Constitution intended things to be temporary. It specified the number of years for which it would apply. Yes. 5 in one instance, 10 in another, 15 in a third. Yes. But as far as Article 370 is concerned, they did not specify the time for which it would apply. And as you explained, it's only temporary because of the nature of its relationship with the Constituent Assembly. Till the Constituent Assembly was appointed, the powers could be enforced with the concurrence of the state government. After the Constituent Assembly was convened, it required the Constituent Assembly's concurrence. That's why the word temporary is there. Is that right?
Because even a state government has a power under 370 till assembly meets.
And no further.
No further.
Now, Article 370 may have been devised to ring fence and protect Kashmir's autonomy, but the truth is, since 1950, a number of articles of the Indian Constitution have been extended and apply in Jammu and Kashmir. I'm talking about the Supreme Court, the CAG, the Election Commission, Article 356, the concept of President's rule. So today, how much of the Indian Constitution actually applies in Kashmir?
Almost the entire constitution. This has not been discussed in media. You see, more than 260 articles have been applied to Jammu and Kashmir. Out of 97 items on which Parliament can legislate, 94 have already been extended. And about remaining 130, there is a constitution of Jammu and Kashmir, which is identical with Indian constitution on power of a speaker, power of deputy speaker, legislative assembly, governor oath, privileges, anti-defection law. It is absolutely identical with Indian constitution.
So, in a very real sense, this is what people mean when they say over time 370 had hollowed out.
I feel so that the celebrations on 370 being abrogated or scrapped or diluted are out of proportion. Similarly, the grief in Jammu and Kashmir is also out of proportion. Delhi has not got something very substantial and great, and they have not lost something very great.
But the important point you're making is virtually all the articles of the Indian Constitution either have been made in the last 40, 50 years applicable to Jammu and Kashmir, or were identical to articles that already existed in the Jammu and Kashmir Constitution.
True.
Let's then at this point come to what the deoperationalization of 370 means today. First of all, Law Minister Ravi Shankar Prasad has gone on record to say that there are several laws and acts of Parliament which he believes did not apply before 370 was deoperationalized and will apply now. He's talking specifically about the Prevention of Corruption Act, the Right to Education Act, the Right to Information Act, the Prohibition of Child Marriage Act, as well as the law preventing manual scavenging. To what extent is he correct, and to what extent is he misleading?
Difficult to say anything against the law minister, but the fact is, manual scavenging, they had a 2010 law. On RTI, they had a law in 2004, in 2009, entire Indian law was made applicable to them. They enacted their own law, but it is identical with our Right to Information Act. On prevention of corruption, they have a law which in certain aspects is better than our law. And if you look at state reorganization bill, 166 of their laws have been retained, about 164 of laws have been repealed, and 106 laws have been extended. And what have been repealed are the laws which were already applied to them. Say the Hindu Marriage Act, it was already applied to them. Minority and Guardianship Act, it was applied to them. Now we are reapplying to them.
But you're saying a very important thing. There are some measures which Mr. Prasad believes will apply for the first time in Jammu and Kashmir, and you're pointing out that actually, as far as those measures are concerned, Kashmir's own laws were probably better. One example is the Right to Information Act. Kashmir's own Right to Information Act has less exemptions than the new Indian law which will apply. And secondly,
already applied in 2009.
And secondly, the status of state information commissioners in Jammu and Kashmir was greater than it is under the Indian law. In Kashmir, they equated with High Court judges. In India, they equate with chief secretaries of state. So here, although there's a change, it may not be a change for the better.
No, education, for instance, their right to education in their constitution itself is free education up to university level. Our right to education gives right to education between 6 to 14 years.
This is another example where the law minister claims that in fact RTE, the right to education, will be applying in Jammu and Kashmir, insisting it didn't apply earlier. You're pointing out that their own constitution had better terms and enforced free education up to university. So in both these instances, the law minister is wrong.
You can say so, but number of things we have not studied their constitution. Say what secular and socialist in their constitution occurs in 1956. In our constitution, it will come in 1976.
In other words, they had committed themselves to secularism and socialism in their own constitution 15 to 20 years before the Indian constitution committed us to it.
Yes.
That's very interesting. However, the government lays a lot of stress on its claim that women's rights have been enhanced in Jammu and Kashmir by deoperationalizing Article 370. And in particular, they point to the fact that the Triple Talaq Act will now apply in Jammu and Kashmir. Do you believe there's been a significant enhancement in women's rights? Or once again, is this a mixed picture?
It's a mixed picture because before 2007, the Shariat Application Act was not applicable to Jammu and Kashmir. And Muslims there were governed by Shri Pratap Consolidation of Laws of 1930s. Now, under that law, if there is a difference between custom and statutory law, the custom shall prevail. And Kashmiri Muslims were not governed by Muslim personal law, but were governed by customs. And these customs were at variance with Islamic law. I give you one example. In Islamic law, they don't make a distinction between married daughter who is living with husband and unmarried daughter. There is a difference. In Kashmir, they have Dokhtare Khana Nasheen and Dokhtare Khana Birun. Now, this Dokhtare Khana Nasheen, married daughter who lives with his father, gets a share equal to son. Similarly, in Islamic law, adoption is not allowed. But in Kashmir, Pisare Parvarda gets a share. So, there are things where they were, say, Muslim marriage registration law. In rest of the country, Muslim marriage registration is not compulsory. In Kashmir, it was compulsory.
So you're saying to me that because customary law took precedence in Kashmir over statutory law, and because women's rights in customary law were a lot greater, Kashmir actually had very strong women's rights, particularly giving rights to unmarried daughters equivalent to those of married daughters.
Married daughter getting, who is living with father getting a share equal to son. Otherwise, in Islam, you know, the daughters will get half a share. There they were getting the same share. But interestingly, this 2007 application of Shariat Act has now been repealed. So we do not know as of now by what law Kashmiri Muslims are going to be governed.
So until the 2007 complication came in, actually women's rights in Kashmir, which were determined by customary law, were in some senses much stronger.
I give you another illustration. You know,
but is that correct?
Yeah, it's correct in a few senses. I give you one example. It is said that a married daughter who a permanent resident of Kashmir, if she marries an outsider, then she or her children will not get the right to property. It's a myth. If you look at that 1920 law, it's the other way around. If an outsider male marries a Kashmiri girl, this male cannot become permanent resident. But if an Kashmiri permanent resident female marries an outsider and this man dies, then she gets everything.
This is very interesting because one of the claims the government has made that rights will have increased as a result of deoperationalizing 370 is to do with the right of Kashmiri women to inherit. I want you to clarify this because it's very important. The government says when 370 existed, if Kashmiri women married non-residents, they couldn't inherit property. You're saying that was wrong, they always could. It's the man who couldn't, they could.
No, Kashmir's High Court in 2016 in the Sushila case clarified it, that this is a myth that she does not inherit. She indeed inherits. It's an outsider male who marries a Kashmiri girl who was at a disadvantage.
So on this specific issue of Kashmiri women inheriting if they marry non-residents, you're saying a wrong picture has been understood.
Yes.
Kashmiri women always had the right to inherit. It was the non-resident male who would not have inherited. But the woman who's Kashmiri would have inherited regardless of whether she'd married a fellow Kashmiri or a non-resident.
Correct.
Correct. So this was clarified by the court in 2016.
Yeah, Sushila's case.
But the impression outside Kashmir is therefore a misunderstanding. And when the law minister says that this is one area where rights have increased, he's going by the misunderstanding. He's not going by the real situation.
Because truth has become irrelevant. We live in post-truth world.
There is one other claim the government makes, that as a result of 370 being deoperationalized, there will be increased rights. They claim that now there will be reservations in Kashmir for the scheduled castes and for the Bakarwals. Is that claim correct? Or is it exaggerated?
It is exaggerated because already there is a reservation for SCs, STs and BCs. They have their Reservation Act, and this reservation law is also very progressive. For instance, it says reservation shall be in proportion to population. It says reservation will not be more than 50%. It says if the seats are not filled in 1 year, they will carry forward.
In all these respects,
yes,
the reservation law in Kashmir is better than the reservation law in the rest of India.
Yeah,
that's what you're saying.
Yes, because...
And I'm just stopping. And you're also saying that actually reservations for scheduled castes and scheduled tribes did exist in Kashmir.
Yes, there is a Reservation Act. 2004.
So the government's claim that the deoperationalization of 370 makes reservations applicable in Kashmir for the first time again is wrong.
You see,
But yes, it is wrong, isn't it?
I would say that they are not really appreciating what was the law existing at that point of time.
And because they haven't appreciated it, their claim is wrong.
I'm telling you, under Article 341 and 342, the President of India notifies caste as SCs for a particular state and caste as tribes as STs. So 13 castes had been notified as scheduled castes for Kashmir, and 11 tribes had already, including Gujars and Bakarwals. So they are already there since 1989.
And they already had reservations.
Yes.
So the claim the law minister makes that now for the first time there will be reservations for SCs, STs and the Bakarwals is wrong.
There is a...
Why are you hesitating to say it's wrong?
I'm hesitating because the question is whether outsiders will get a reservation. Now, there are Supreme Court judgments which say that scheduled caste and scheduled tribe should be in relation to the state. Now, if it is to be in relation to the state, outside SCs and STs may not get the jobs. In fact, in Jammu already, BJP people themselves are saying we don't want outsiders to come over here.
I understand, but this is a fine point to do with how you understand a ruling by the Supreme Court on whether outside SC and STs get reservations in a state. But the real point which the law minister made is that prior to the deoperationalization of 370, there were no reservations for SC, STs and Bakarwal. That point was wrong. That point is wrong.
Yeah, there were reservations.
And so there the minister is wrong.
Yeah.
Yes?
Yes.
Now I want to come at this point to a very interesting paradoxical point. And it's one that I indicated in my introduction to this interview. There are several critical instances where, as a result of deoperationalizing 370, Delhi's powers in Jammu and Kashmir have actually reduced. And the reason is that when 370 existed, Delhi had more powers in Jammu and Kashmir than it does in all the other states. I'm talking with specific reference to the fact that 370 made it easier to repeatedly extend President's rule in Jammu and Kashmir compared to any other state. 370 made it easier for the Delhi government to take over the state's powers in terms of subjects mentioned in the state list of the Constitution. Again, 370 made it easier to impose an emergency in Jammu and Kashmir on grounds of internal disturbance. And finally, 370 made it easier to impose additional restrictions on freedom of speech, additional to those mentioned in Article 19, compared to the other states. These are four critical areas where 370 gave Delhi greater power in Jammu and Kashmir compared to all the other states. Now that ceases to be the case.
Karan, this is the best question raised on entire controversy of 370 in last 3 weeks. Let me answer it in some details. In fact, we have lost more power because of what has happened in last 3 weeks.
We meaning Delhi?
Delhi. Yeah, of course, I identify with Delhi rather than with Kashmir. So, say we can impose national emergency and it can be imposed in a part of our country also, only on the ground of armed rebellion or external aggression. In Kashmir, they can impose national emergency on ground of internal disturbance. This was the ground on which Indira Gandhi had imposed emergency in 75, and this was the ground which 44th Amendment deleted, but it was not extended to Jammu and Kashmir. Similarly, after 44th Amendment, now even during emergency, my right to life and personal liberty cannot be derogated at all, but we did not extend it to Jammu and Kashmir. You talked about freedom of speech. Now, reasonable restrictions on freedom of speech can be imposed, which are given under Article 19, Clause 2. But for Kashmir, we made a modification under 370. And what did we say? That the restrictions which appropriate legislature thinks reasonable. So there is no judicial review of denial of freedom of speech in Kashmir. Similarly, about your right to reside and settle anywhere in India, the restriction under Article 19 can be imposed in the interest of scheduled tribe. But for Kashmir, the expression is in the interest of security of a state.
And similarly too, the Delhi government could with much greater ease exercise authority on subjects that are listed in the state list in the case of Jammu and Kashmir than it could in the case of any other state.
Article 249. Now, for rest of the states, the resolution of Rajya Sabha must mention something. So it will mention an item given in a state list. For Jammu and Kashmir, resolution can mention any article, any subject. So the powers of the parliament to legislate are much wider.
So in all these critical areas, and some of these are very, very important critical issues, they're not ordinary issues, what the deoperationalization of 370 has done is to actually take away the special status of Delhi rather than the special status of Kashmir.
Yeah, one more I am reminded of. Precedent rule, maximum limit for other states is 3 years. For Kashmir, it is 7 years.
So this is another area where Delhi's powers over Kashmir, because you've deoperationalized 370, have reduced, they haven't enhanced.
Yes, we have lost a lot of power because of this.
And this also means, and I'm reiterating the point, that 370 didn't just create special status for Kashmir. In critical areas, it actually created special powers and special status for the central government, i.e. for Delhi.
I think that is the central point which we missed in this debate, that 370 was all about special powers of the center. It was not about special powers of Srinagar, because all these years, through presidential orders, Article 370, has almost emptied its contents. It was a shell which has emptied its contents, and therefore it was much more useful for us than for Kashmir.
And this is a misunderstanding of Article 370 that has led many to believe special status of Kashmir has been abolished. Actually, what's been abolished or deoperationalized is special status and special powers that Delhi had.
Definitely. Except the symbolic and sentimental value it had for Kashmiri people, which is important, I am not denying its value, but legally speaking, in terms of power, we had much greater power under 370 than Srinagar.
This is again a very important point. For Kashmiris, 370 was important for sentimental, symbolic reasons. Yeah. For Delhi, it actually was important because it conferred real power on Delhi.
Just to give an example.
And just to finish, power that Delhi could exercise in Jammu and Kashmir, which it cannot exercise in other states. In other words, Delhi's control was disproportionately greater in Jammu and Kashmir. Now that's gone.
Yeah, I agree with you. For instance, if Parliament amends Constitution, it becomes applicable in rest of the country. Now it is the will of the Parliament. But President, which is an executive, he may not extend it to Jammu and Kashmir. Now so we get the benefit, they will not get the benefit.
Now it has to be extended.
It has to be.
And this is very
important.
And
that is the reason why they made it union territory.
This is very important, and this is why I want to reiterate the point that far from the deoperationalization actually removing or abolishing the special status of Kashmir, it's only happened in terms of the sentimental importance of this measure for the Kashmiris. The real reduction has been in the special status of Delhi.
Yes.
Delhi's powers have been reduced.
Yes.
Let's now come to one last point, because we're coming to the end of this interview. Article 370 has been deoperationalized, but Article 371, which confers a whole range of special concessions and special powers to other states, continues. And the states that benefit from 371 are states like Maharashtra and Gujarat, Uttarakhand and Himachal Pradesh, Telangana and Andhra, the whole of the Northeast, and the Adivasi areas that are designated as scheduled territories. What do you make of the fact that 370 has been deoperationalized, but 371 continues?
You see, this whole idea of uniformity, that we have one law, one country, one language, one religion, is not constitutionally correct. Therefore, center's relationship with state may differ from state to state. So about Nagaland, any parliamentary law which we pass, it will not be extended to them till their assembly endorses it.
Which is precisely
yes.
what 370 did for Kashmir.
Yes, even criminal law, we have not extended there. Naga custom, will prevail over our laws. Same is about as many as 8 other states. So I feel this is good, that we don't have one uniform relationship with all this.
Because it reflects the reality of India.
Yeah, and the diversity.
But you're making a very important point. Several powers or concessions that Kashmir enjoyed under 370 are also enjoyed by Nagaland.
In a different sense.
But one is that laws passed by Parliament do not become applicable in Nagaland unless accepted by the Legislative Assembly of the state. Precisely that applied in Jammu and Kashmir. But that has now ceased to be in the case of Jammu and Kashmir. It continues in the case of Nagaland.
Yes.
Isn't that unfair? Why
No,
doesn't
it looks unfair, but more than that, even assembly, Naga assembly cannot pass laws for all districts. So even at the district level, I think the name of the district is Tuzang or something, you need a ratification by their council, municipal board or something, etc. So federalism is all about that different people have different kind of autonomy and they come together.
And secondly, something else that seems to have irritated people is that Article 370 permitted Article 35A, which restricted non-residents acquiring property in Kashmir. But you have similar restrictions on outsiders acquiring property in Himachal Pradesh and Uttarakhand, and those continue.
Yes.
So once again, isn't there an element of unfairness? You remove it in one case but allow it to continue in another.
That's why Jammu's BJP is a chief, I think Kuldeep Singh or something, has said we don't want that outsiders come and purchase properties in Jammu. We want similar kind of restrictions being reimposed in Jammu and Kashmir.
So here's the chief of the BJP in Jammu
Yes.
actually saying, I'm terribly scared. Now that you've removed 35A, outsiders will come and acquire property. We don't want that. Please reimpose the restrictions that originally existed anyway.
Yeah, because if you look at number of states, they have domicile reservation. Now recently Jagan in Andhra Pradesh said 75% jobs should go to locals. In most national law universities, we have 50% reservation for the state in which that university is located.
So then let me interrupt and ask you this. Why is it that special provisions for Jammu and Kashmir have been removed, but almost identical special concessions exist for Nagaland? And by the way, according to the newspapers, the peace negotiations that the government is carrying on with the NSCN, according to newspaper reports, could even include giving them their own constitution and their own flag, two things that have been removed from Jammu and Kashmir. So why is it that in one case it's been removed and in the other it exists, or it might even be expanded? Is it because Kashmir is Muslim?
I really don't know, but I personally feel if some states have special status and they feel being an integral part of India, it is better if our states are satisfied. You know, those countries which do not concede power to the state and don't believe in federalism, their secessionist activities will have see a rise.
And surely that will be the case in Jammu and Kashmir when they become aware that the very provisions they've lost either still exist in the case of Nagaland or may be expanded, if newspaper reports are correct, to give the Nagas their own constitution and their own flag. That will fuel anger in Jammu and Kashmir and possibly fuel secession.
Possible, but who knows that protection to Nagas and other states will continue forever.
That's also possible. Now let me give you the explanation the law minister has given for the differential treatment of 370 versus 371. He says 370, in his eyes, is a temporary provision. 371 was a special provision, which is why 370 has been deoperationalized and which is why 371 continues. Do you accept that distinction?
Not really, because you see, Supreme Court has said that Kashmir 370 is special and permanent. So that two are not entirely distinct. Any different dispensation is a special dispensation. So Kashmir has a different dispensation, so it was a special status.
Let me raise at this point a very important concern which you touched upon when you mentioned the Supreme Court. The Supreme Court has frequently ruled that Article 370 cannot be abrogated unless you get the concurrence of the Constituent Assembly, and most recently this was done by Rohinton Nariman, a Supreme Court judge.
SBI case.
As recently as 2016.
Yes.
The government, in acting, has gone in violation of what the Supreme Court has repeatedly said. Could that become a problem for the government?
It won't. We think that the only case which Parliament has overturned a Supreme Court judgment was Shahbano. But this year itself, SC/ST reservation, SC/ST Atrocities Act, there was a judgment last year of the Supreme Court, then Parliament overturned it. So Parliament does have the power to overturn the Supreme Court judgment, including in this case. And that is exactly what this amendment did, that the Constituent Assembly will now mean Legislative Assembly.
So in other words, Parliament has the power to overturn and disregard what Rohinton Nariman, a Supreme Court judge, said, and there's very little the Supreme Court can do about it.
Yes, that's what the parliamentary democracy is all about. One last point. In the entire process of our discussions on 370, we have missed that governor who will take over the power of the state, as a state government, he has to act on the advice of Council of Ministers. There is no Council of Ministers. So mere governor's concurrence will not mean concurrence of the government.
And in critical areas, in either amending 370 or splitting the state and demoting the two parts into union territories, the central government has acted with what they call the concurrence of the governor. And you're now pointing out that concurrence of the governor is invalid because it doesn't have the support of the Council of Ministers behind it.
Even as per the latest amendment.
Even as per the latest amendment.
That's what I'm saying.
So this is yet another
and
problem.
On which day that concurrence was given.
So this is yet another problem. Now we have a whole list of problems, some that we discussed at the beginning of the interview, two that we've discussed just now. The first is to do with the fact that you don't have the concurrence of the governor. The earlier one was the fact that the Supreme Court, even as recently as 2016, has said you can't abrogate without the concurrence of the Constituent Assembly. You still believe, despite these four reasons, that the Supreme Court won't effectively step in and overturn things. It will not show urgency, as you said earlier, and it will push the matter to a constituent bench, which could take 3-4 years to be formed, and by then everything will be a fait accompli. You still stand by that?
I'm inclined, because the way the court operates, they have very, very important matters already listed before the Constitution bench. So that is a routine wait. But I'm really thinking of this, that since the assembly is not there, Parliament is acting as assembly. Now, can Parliament acting as assembly can do such a drastic thing? I think this is absolutely against the text as well as the
if the
spirit of the
Supreme
Constitution.
Court doesn't accept a challenge and strike this down, many will argue this is proof of the Supreme Court's pusillanimity or cowardice, that they are reluctant to challenge or overturn a decision of a majority government. That won't show up our Supreme Court in a good light.
Yes, but we had such incidents. You had ADM Jabalpur, you had AK Gopalan.
You could see ADM Jabalpur being repeated all over again in this instance. That's your fear?
I think so, that probably we are heading in that direction, unfortunately. It may not happen. Sometimes the judges do surprise us. Indira Gandhi was all powerful and one single judge in Allahabad struck down her election.
We need something similar if the principles and the spirit of the Constitution is to be upheld. Spirit and principles as you adumbrated them earlier on.
No, I would say as a student of law that at least I would like to see that kind of debate happening in the Supreme Court. Parliament was asserting its power to amend any provision of the Constitution, and Nani Palkiwala is standing up and saying that there are implied limitations on the power of the Parliament. So in this case also, I would like to see whether Supreme Court really upholds the Constitution and believes it is not enough that there is a law passed by the Parliament, but this law is just, fair and reasonable.
My last issue. The government claims that the real reason to strike down or deoperationalize 370 is because it was permitting, even encouraging, corruption and terrorism. How do you respond to that?
Possible. Government maybe know of that information, but you have Naxal terrorism as well. Now, and as many as 18 states are affected by that. So they don't have any special status or Article 370. I'm reminded of Paul Wilkinson. Now, he says that the settled strategy of terrorist world over is that it would like to see that a civilized state indulges in state terrorism. When a state indulges in state terrorism, then they will go to their constituency, people who have been adversely affected, and convince them that you have been unjustly treated. And then people fight against those injustices. So if we really want to curb down terrorism, we must ensure that there are no injustices anywhere in our country.
But you're making a very important point. If Naxalism can exist in 18 states where there is no 370, then it's hard to say conclusively that 370 is the reason why you have terrorism in Jammu and Kashmir. There could be a lot of other reasons, including the point you made: injustice, mishandling, political interference, etc.
Yeah, even on corruption.
What about corruption? Yes, come
Even
to
on corruption, say this PDS leakage. In Gujarat, in UP, you have, in Delhi even, more than 70% leakage. In Kashmir, you had about 7 or 8%. So you have corruption all over. India's ranking in the transparency index is not very high.
Once again, you're saying 370 is not the actual reason why you have corruption.
It may not be the only reason, I'm saying.
And you're also pointing out that in terms of leakage of PDS, it's a lot higher in states like Gujarat than it is in Kashmir.
You know, on number of parameters, Kashmir has been doing better than other states.
Particularly including corruption.
You can say that.
Finally, the government has also said that Article 370 was an obstacle to development. Was it?
I really don't know. Possible, because this is not a legal question. So I may not give you an answer based.
The critical point people make is that under Article 35A, outsiders and therefore industry couldn't acquire land. But from the Farooq Abdullah government onwards, Kashmir has made it clear that they're willing to give 99 and 100-year leases. The critical question then, is a 100-year lease or a 99-year lease sufficient to encourage industry? Is it a discouragement because they don't have outright use of land? Do you have any sense of that?
I'm not the right person to answer this question, because I don't really follow how corporates make investments. But generally, I think 99-year lease should be good enough.
Finally, and I'm going back to the issue with which we began, because I think it's very important. As you pointed out, Article 370 has not been abrogated.
Correct.
It exists on the statute books.
Yes.
It's still part of the Constitution.
Yes.
All that's happened is that it's been de-operationalized.
Yes.
Doesn't this mean that theoretically, if there is a government in the future with a majority, and secondly with the will to do so, it can re-operationalize Article 370. It can use precisely the same procedure to reverse what this government has done.
Theoretically, yes, but no government would like to do that.
But theoretically, the option is open.
Option is open because any central government would want its control in all the states. So no central government would like to, give autonomy to a state.
But theoretically, because Article 370 is not abrogated, the same process by which it has been de-operationalized can be used by a future government to re-operationalize it. The only question is, will such a government want to do it? It's the question of will it be done that's in doubt. Theoretically, it could be.
It could be, but I don't think any central government would like to do it.
Professor Faizan Mustafa, thank you very much for clarifying in detail and with such insight an issue that is quite complicated and difficult for people to understand. I think now most people's understanding of exactly what has happened in Jammu and Kashmir, the extent to which it's legal and legitimate, and where it leaves the relationship between the state and the rest of the country will be far clearer.
Thank you so much, Karan. Thank you so much.
To receive instant updates on all videos from The Wire, click the subscribe button and hit the bell icon. Pay to support independent journalism. Click the link in the description and choose the amount you want to pay.